Hi everyone, welcome to week 9 of administrative law. This week we'll be looking at the ground review of natural justice or procedural fairness. So this is another one of the grounds of review that we're looking at as an avenue for judicial review in this unit. And we'll start off by talking about procedural fairness. And it's worth quickly noting the distinction between natural justice and procedural fairness. Procedural fairness, it really captures what we're looking at in this ground of review. We're looking at whether the process has been fair to the person who's affected by the decision. Have they been given a right to be heard? Is their decision maker free from bias? Things like that. The Administrative Decisions Judicial Review Act provides a ground of review under natural justice. And really what that's doing is it's capturing these notions of procedural fairness under the label natural justice. And so we'll sort of bounce between the two terms, natural justice being the phrasing in legislation, but procedural fairness arguably doing a better job of capturing what we're trying to get at in this ground of review. So we'll start off with a broad overview. Then we'll talk about when procedural fairness will apply. And in particular, what's really important is the implication principle. We'll also briefly touch on four ways in which procedural fairness will usually apply. And conversely, we'll look at some of the factors that might lead to qualify or limit the implication principle and procedural fairness applying. Then we'll turn to the content of procedural fairness, and in particular, we'll look at the hearing rule and the rule against bias. So let's start with an introduction to procedural fairness. And as I've said, it's founded in these common law principles of natural justice, which includes these notions of acting judicially, so reviewing evidence that's presented before it and determining a dispute between two parties. Not acting arbitrarily, so having regard to the facts, having regard to the requirements of law and things like that. Acting without bias or prejudice, so having an unbiased mind. Acting proportionally, so making sure that the decision fits with the factual matrix that's before the decision maker. Concepts of fairness, so what's fair and equitable under the circumstances, I know it's a very vague term, but what's the right outcome in this case? And finally, a level of detachment or independence, which is tricky to achieve with decisions made under the executive, but we want decisions to be made independent of factors that shouldn't bear on the decision. So, for example, corruption, irrelevant considerations, which we talked about in week 8. We want the decision to be made as independently as possible in order to reach as fair an outcome as possible. Let's think about the circumstances under which a procedural fairness will apply. And as I've said, this is provided for under the Administrative Decisions Judicial Review Act. Section 5(1)(a) provides for a review on the ground that a breach of the rules of natural justice has occurred in connection with the making of a decision. But there's a bit of a catch. And in particular, Justice Mason in Kiowa and West said that this section doesn't impose an obligation to apply the rules of natural justice, where apart from Section 5, there would be no obligation on a person. So we can't rely specifically on Section 5 to require a decision maker to follow natural justice and procedural fairness. There has to be some other requirement or obligation on the decision maker to afford the person who's affected natural justice. Usually that other place is going to be common law. And in Kiowa and West, Justice Brennan said that when the legislature creates certain powers, the courts presume that the legislature intends the principles of natural justice to be observed in their exercise in the absence of a clear contrary intention. So And this comes back to the rule of law and principles of separation of powers, where the legislature creates powers that the executive government can use, the courts, acting as a check and a balance on the use of those powers, presume that natural justice should apply unless it's very clearly stated that they won't. This was highlighted in Kiowa and West, and this is really a classic case in administrative law that you should be aware of. The Kiowas were a family from Tonga. They initially were in on Australia on a 3-month student visa for Mr. Kiowa. However, the Kiowa's family back in Tonga then experienced some financial hardship as a result of a cyclone. And so Mr. Kiowa and his family decided to stay in Australia so that he could work and send some money back home to his family in Tonga so that they could be sort of supported through their financial difficulties. About 15 months after he was due to leave, after his visa expired, Mr. Kiowa was arrested, and the arrangement was made for him to be deported. And the decision maker made a particular note citing concern, Mr. Kiowa's concern for other Tongan illegal immigrants and Mr. Kiowa's active involvement with other people who are seeking to circumvent Australia's immigration laws. That was one of the reasons cited for deporting Mr. Kiowa. Of course, that wasn't quite what was going on. The money was being sent to Mr. Kiowa's family back in Tonga because they were undergoing financial hardship. He wasn't sending it to them so that they could come to Australia as well. But Mr. Kiowa was never afforded the right to respond to those allegations, where he would have been able to say, no, that's not what I was trying to do at all. He had no chance to explain himself. And accordingly, he was denied natural justice because he was given no opportunity to respond to those allegations that were made against him. So that case really clearly highlights that even though natural justice may be expressly provided for in statute, often it's not. And instead, it will usually be implied through the common law, which holds that the judiciary is there to make sure that procedural fairness and natural justice is afforded. Like in Kiowa and West, the court's there to make sure that people who are affected by administrative decisions have the chance to respond to the case that's been made out against them. The court acknowledges that natural justice and procedural fairness can be expressly excluded, but only in very explicit circumstances, and the court will read that very narrowly. So Parliament, as acting as a representative of the people, can restrict procedural fairness. A good example is in some of the anti-terrorism legislation where, under very limited circumstances, people can be held without trial and things like that. This is going to be read very narrowly because the court presumes that people's rights won't be interfered with unless that's the express intention. So 4 sort of common scenarios where we would expect for procedural fairness to apply, where we would expect common law to imply natural justice, would be where someone suffers a direct detriment to an existing benefit. If someone is currently enjoying a benefit and that's going to be impacted in some way, we would expect that they should have the opportunity to respond to that. Where adverse allegations or objections are being made against someone, they should have the right to respond. Where someone has a legitimate expectation of receiving a benefit, so for example, where one person has received a benefit and then a second person is in the same situation and therefore would expect a same outcome, but they don't get that, you would expect that they would have a right to question that. And lastly, a legitimate expectation of being heard. And we'll talk about that in a bit more detail in relation to the hearing rule in a moment. In thinking in a bit more detail about when procedural fairness will apply, Justice Gray in Work Cover Corporation of South Australia and Davey summarised some of the factors that might go into determining whether natural justice will apply or not. I won't go through them all. They're listed in your study guide as well. But broadly thinking about when a decision is final, out in the public, there's a list of formalities, it's judicial of nature, we would expect procedural fairness to really apply in those sorts of scenarios. But when judicial fairness will apply or not isn't really the key issue. It's important as a preliminary step to establish that natural justice and procedural fairness should apply. But since Kiowa and West, the presumption really is that it will apply, and that especially under common law, we can expect procedural fairness. Instead, Justice Mason identifies that the content of procedural fairness is what's more important. So I've got a couple of quotes here from Kiowa and West where Justice Mason said that the critical question in most cases is not whether the principles of natural justice apply, it's what does the duty to act fairly require in the circumstances of that particular case. So usually it's pretty uncontroversial that procedural fairness will apply, and instead what's at issue is what do we have to do to give effect to procedural fairness? And that depends on the circumstances of the case. So what is appropriate in terms of natural justice depends on the circumstances of the case, the nature of the inquiry, subject matter, and the rules under which the decision maker is acting. So content is more important than whether it applies or not, because we can usually pretty safely assume that procedural fairness will be required. So in thinking about the content, there's two rules that are especially important, the hearing rule and the rule against bias. So we'll look at those in a bit more detail. Firstly, looking at the hearing rule, there are three minimum requirements. First, that a person will receive notice that a decision has been made. Secondly, that there will be a disclosure or an outline of the substance of the information on which the decision is based, and an opportunity to comment on that information and to present the individual's case. So the hearing rule requires that people are notified that a decision's been made against them or that affects them, the reasons for decision essentially, so a disclosure of the outline and substance of that decision, and the opportunity to respond to that decision and the information on which that decision has been based. So this might be within the actual decision-making process itself. So a notice that this is what's happening, this is the evidence that's before us. Before we make our decision, you need to let us know if there's anything else relevant. Or it can be provided for afterwards in the sense of the explicit availability, say, of merits review. So the opportunity for a person to correct the decision through a merits review process might be another way of providing a procedural fairness via the hearing rule, allowing a person to sort of present their case. Some things that aren't usually required or generally required under the hearing rule, you don't necessarily have the right to an oral hearing. So it can be okay just for written submissions, written presentation of evidence, submitting forms, documents, whatever it is. The right to hearing doesn't necessarily mean right to show up either at the decision makers, in a meeting room there, or right to show up at a merits review tribunal like the AAT. You don't have to necessarily go that far in order to be heard. there's usually not a right to cross-examination, and similarly, usually not a right to representation. So you don't necessarily have a right to legal representation in order to be heard. The rules of evidence are also an interesting one, and we talked a little bit about this in week 6 when we talked about the no evidence rule. But as a general rule, the decision maker does not have to be bound by the rules of evidence that a court is required to take notice of. So, for example, hearsay or grey areas around the use of expert witnesses, things like that. That doesn't necessarily have to, a decision maker doesn't necessarily have to follow those rules too, and they can take into account a broader array of evidence that a court might not be able to in making their decision, and that won't affect the hearing rule. A person will still be considered to have been heard, even if the decision maker also admits hearsay evidence or something like that. But sort of counterweighted against that is the requirement that the decision maker have some evidence to support their decision. So that ground of review that we talked about in week 6 in relation to no evidence. If the decision maker's decision is not supported by fact or purported to be supported by a fact that's not actually true, then that might itself be a problem that can also mean that a person has not been heard and the procedural fairness hasn't been given to them in that instance. The second sort of key element of procedural fairness is the rule against bias. And the general test for that comes to us from laws and the Australian Broadcasting Tribunal, which provides that the test is whether a fair-minded person might reasonably suspect that the decision maker might not resolve the issue with a fair and unprejudiced mind. So in laws and the Australian Broadcasting Tribunal, there were a few things all kind of going on at the same time, but Laws had John Laws, was a radio presenter and a bit of a shock jock. He made a few comments and invited listeners to make some call-ins that made some quite racist remarks about Indigenous Australians. Several complaints were filed, including a complaint from the Minister for Aboriginal Affairs and Legal Services to the Australian Broadcasting Tribunal. And so the tribunal had to look into Laws' radio show and decide whether the program had breached the rules under the broadcasting regulations. At the tribunal sort of publicised some of its preliminary decisions, and Laws then sued the tribunal for defamation as well. And so there was then a concern that because the tribunal members of the tribunal were being sued for defamation, that they would be biased in their case, in the case against Laws. There's some clarity in relation to what will actually cloud a decision maker's mind in relation to bias from Chief Justice Gleeson and Justice Gummow in the Minister for Immigration and Multicultural Affairs and GIA. And in that case, they said that the question's not whether the decision maker's mind is blank, it's whether it's open to persuasion. So the question is not, is the decision maker a blank canvas and whatever a decision comes to them will just be filled from the facts that are presented before them. A decision maker can have a preliminary or an early notion of where things are going to go, what the decision's going to be. But as long as they are open to evidence to the contrary, as long as they are open to changing their mind, then it doesn't matter that they've got a preconceived idea of what the decision is going to be. And that was relevant in Laws and Australian Broadcasting Tribunal because the tribunal had already made a preliminary decision. And so it wasn't biased that then the final decision was similar to that preliminary decision, as long as they were going to be open to evidence to the contrary and willing to listen to Laws's arguments and willing to change their mind if they needed to. To give a bit more detail on the rule against bias, something that's quite critical is that the bias can be actual or apprehended. So a person can be actually biased, and in which case, obviously, that's going to violate the rule against bias. But bias can also be apprehended. So a person might not necessarily actually be biased, but if the sort of general perception in the community would be that this person might be a bit biased, this person might not resolve the issue with a fair and unprejudiced mind, someone might, reasonably suspect that that's what would happen, then that would violate the rule against bias, even if the decision maker is not necessarily biased themselves. And in Webb and the Crown, Justice Deane provided sort of a summary of 4 different kinds of bias. So someone can violate the rule against bias by having an interest, so a pecuniary or a material interest. They've got some stake in the outcome themselves. For example, they stand to make money if the decision is resolved in a certain way or something like that. Obviously, that's going to be pretty biased. Disqualification by conduct. So the way that a person behaves leads you to suspect that they're biased. So, for example, not giving the other person a right to a chance to be heard or present their case might indicate that the decision maker is actually biased. Disqualification by association. So, for example, a spouse stands to gain a material interest based on the decision, something like that. There's clearly a connection there, which is going to be problematic. And lastly, disqualification by extraneous information. So if it's clear that a decision maker is taking into account, for example, irrelevant considerations, that might clue us on to the fact that the decision maker is biased in some way as well. To wrap up, there are some very limited circumstances where bias will be tolerated. The first sort of exception is where the bias is waived. So the person who's affected or detrimented by the bias knows or suspects that the decision maker is biased but doesn't do anything about it, or even expressly allows that to go ahead. So, but usually the way that plays out is that the person becomes aware that there is potential bias but doesn't object to that bias promptly. If they let it sit for a long time and then suddenly they've got a problem with it, you have to sort of question, well, why was this not a problem straight away? And if there's no good explanation for that, then we would consider that that's been waived. The second reason why bias might be tolerated is under the doctrine of necessity. And this would occur where no decision maker is available because all the potential decision makers are tainted by this apprehension of bias. And that's what came into play in Laws and the Australian Broadcasting Tribunal. Because Laws had a case against the tribunal as a whole for defamation, the entire tribunal was tainted by this apprehension of bias, that they wouldn't resolve his matter with a fair and open mind. So the court said, well, they have to make a decision anyway, and we just have to trust that they will do so in the right way, because we can't refer this to some other decision maker because they're all tainted by this same apprehension of bias. So where no decision maker is available who isn't tainted by that bias, then it's necessary for them to still make the decision anyway. And so the rule against bias would be permitted under those circumstances. That draws our week 9 lecture video to a close. By way of a quick recap, what's important to think about is, firstly, is procedural fairness and the requirements of natural justice going to apply? Almost invariably, their answer will be yes because of the implication principle. Common law implies that procedural fairness will be a requirement unless it's expressly excluded under statute. What's more important is the content of the procedural fairness itself. That's going to be determined on a case-by-case basis, thinking about what do we need to do to make this fair. But two really key elements are a right to be heard and a rule against bias. So we would invariably expect that a person should be given a chance to present their case and that the decision maker shouldn't be biased. If we don't have either of those things, then we couldn't say that the person has been granted procedural fairness. That's not to say that those are the only things. And looking at the facts of the case, it might be that there are other things that we would expect in order to give effect to procedural fairness. A good example might be providing a translator for someone who doesn't fluently speak English in relation to a decision. We might expect that on those circumstances, in order to achieve natural justice, the decision maker should make sure that, the person is fully informed of the process and what's going on, and providing a translator would go towards that. But it's to be determined on the facts of each case. And so it's hard to give sweeping statements of what will be required all the time, other than these two rules that we've talked about, the rule against the hearing rule and the rule against bias. We will leave it there for week 9. Next week, we pick up our final ground of review, which is looking at unreasonableness and when a decision is so unreasonable that the court will set it aside. So we'll see you then. Thanks very much for watching.